ये मैटर जो मैं आपको बोलने जा रहा हूँ, आप इस मैटर को हमारे सॉफ्टवेयर पे टाइप करके आप अपनी मिस्टेक्स को जान सकते हैं और अपने शॉर्टहैंड को इम्प्रूव कर सकते हैं, जिसका लिंक मैंने अपने डिस्क्रिप्शन बॉक्स में दे दिया है।
3, 2, 1, start. This appeal has been filed against the judgment dated 21/5/2015 of High Court of Punjab and Haryana, by which LPA number 1747 of 2014 filed by the appellant has been dismissed. LPA was filed by the appellant challenging the judgment of learned single judge dated 20th/4/2013 in civil writ petition number 3037 of 2003, by which judgment learned single judge had dismissed the writ petition filed by the appellant praying for grant of pension by adding interruption of service between 1/2/1988 to 3/8/1994. The appellant was initially appointed by Board of School Education Haryana Bhiwani on 8/5/1970 on the post of proofreader. The appellant, due to his family circumstances, voluntarily retired on 1/2/1988. The appellant submitted a representation to the Education Minister of Haryana. The Education Minister Haryana, vide his letter dated 27/3/1993, forwarded the application of the appellant recommending consideration of his case for reappointment on humanitarian ground after treating the period of absence without pay even if B rules have to be relaxed. The board, keeping into view the recommendation of the Education Minister, resolved on 31st/5/1994 granting sanction to reappoint the appellant afresh. It was observed that for giving the benefit of past service, the opinion of the government be obtained. A fresh appointment order dated 25/7/1994 was issued to the appellant for appointment on the post of proofreader in the pay scale of Rs 1400 to 2600, in pursuance of which the appellant joined on 3/8/1994. On 5/12/1994, Secretary of Board wrote to the Secretary of Government of Haryana Education Department seeking clarification on benefit of past service to the appellant. On 5/12/1994, the respondent number 4 clarified that past service of appellant could only be counted for the purpose of seniority and pension after giving the benefit of continuity in service and the period of his break to be treated as leave without pay. The board, vide its resolution dated 31st/5/1995, decided to condone the period from 2/2/1988 to 2/8/1994 by treating the same as leave without pay for continuity of service for the purpose of pension and seniority. The Financial Commissioner and Secretary, Haryana Government Education Department, wrote a letter dated 27/5/1997 regarding giving the benefit of past service to the appellant. The letter referred to Rule 4.23 of Punjab Civil Services Rules Volume 2, which states that period of interruption of 1 year can be condoned for giving the benefit of pension, and whereas in the case of the appellant, the period of 6 years is condoned for the purpose of pension. Clarification was asked for in the above regard. The board asked the appellant on 4/2/1998 to deposit along with interest of to 31st/3/1998 amount with regard to continuity, provident fund, leave encashment, etc. as received by him consequently to voluntary retirement. On 18/1/1999, the Director Local Audit Haryana wrote to the Secretary of the Board that Rule 4.22 of Punjab Civil Services Rules Volume 2 is not attracted and relevant rule is 4.23, which rule only authorized condonation of break of service up to 1 year duration. The condonation can only be made by competent authority in relaxation of provisions of Rule 4.23 of Punjab Civil Services Rules. On 15/5/2000, the appellant deposited the amount with interest up to 31st/3/1998. The Director Secondary Education, vide letter dated 24/8/2000, referring to audit objections requested for obtaining relaxation in Rule 4.23 of Punjab Civil Services rules from Finance Department through Commissioner and Secretary, Haryana Government Education Department. On 24/8/2001, Director Secondary Education Haryana wrote to the Secretary of the Board that Finance Department has declined to accept the proposal and has suggested that the pay of the employee be fixed under footnote number 6 of Rule 7.18 of Punjab Civil Services Rules. The board asked the appellant to deposit interest up to 31/12/2001, which was deposited in 4/1/2002. The appellant retired on 31/5/2000. After retirement, certain retirement benefits were paid to the appellant, which were accepted with protest. On 2/8/2002, appellant submitted a representation to board claiming pension. On 26/11/2002, the appellant was informed that as per Finance Department and as per pension rules, he has already been paid the benefit which were due to you on account of reappointment. In July 2002, the appellant had received the retirement benefits, including the amount which was deposited by the appellant. Civil writ petition number 3037 of 2003 was filed by the appellant claiming pension and other benefits of service for the period service from 8/3/1970 to 31/1/1988 and for addition of interruption of period from 2/2/1988 to 2/8/1994 in his service. Learned single judge referred to Rule 4.23 of Punjab Civil Services Rules. Learned single judge took the view that as per Rule 4.23, if the break in service has been occasioned on account of resignation, dismissal or removal, the period of interruption of service cannot be condoned. Learned single judge further observed that even the order of appointment is a fresh appointment order, it is not possible to compute two different spells of service as a single service. A review petition was filed by the appellant, which too was rejected on 22/11/2013. The learned single judge, while rejecting the review petition, also observed that clause 4.22 of rules is also not attracted. The appellant therefore filed a LPA before the division bench, which has been dismissed on 21/5/2015, against which this appeal has been filed. Learned counsel for the appellant in support of appeal contends that under Rule 4.23, what is not condonable is only in cases where the interruption has been caused by resignation, dismissal or removal from service or due to participation in a strike. He submits that appellant having voluntarily retired, which is not covered in the definition of resignation as mentioned in Rule 4.23, he is entitled for automatic condonation of interruption between 2/2/1988 till 2/8/1994. It is further submitted that the board, having passed resolution for condonation of the aforesaid period and in consequence of which the appellant has deposited the gratuity provident fund and leave encashment amount which was received by him at the time of voluntary retirement, the respondents could not have denied the benefit of adding the interruption period for computing the pension. Resolution was passed by the board on 31/5/1994, which could not have been legally reviewed after 5 years. He submits that the appellant is entitled for the benefit of Rule 4.23 of Punjab Civil Services Rules. Learned counsel for the state, refuting the submission of the appellant, contends that the Rule 4.23 as relied by the appellants is not the relevant rule which is applicable in the state of Haryana. Referring to the counter affidavit, learned counsel submits that in the counter affidavit annexure 1, the relevant clause, that is Rule 4.19, 4.20, 4.21, 4.22 and 4.23 as applicable in the state of Haryana has been filed. He submits that Rule 4.23 Sub-Rule 3 provides that interruption should not be of more than 1 year's duration and In the present case, interruption being of more than 6 years, Rule 4.23 does not help the appellant. He further submits that appellant having accepted voluntary retirement on 1/2/1988 and having joined again on 3/8/1994 as a fresh appointment, the earlier period can be added for the purpose.